Supreme Court Justice Amy Coney Barrett thought her position made her untouchable. Sitting before the Senate Judiciary Committee for a routine oversight hearing, she expected the usual softball questions and deferential treatment that came with her lifetime appointment. What she didn't expect was Pam Bondi, armed with case law that would expose her judicial inconsistencies. And she definitely didn't expect Riley Gaines to light the fuse that would unleash Bondi's legal genius. If you want to see the moment a Supreme Court justice's arrogance met its match, hit that like button, tell us where you're watching from, and subscribe, because this is the story they tried to bury. The Hart Senate office building buzzed with its usual morning energy as senators, staff, and witnesses prepared for what was supposed to be a routine judicial oversight hearing. The Senate Judiciary Committee was conducting its quarterly review of Supreme Court decision-making processes, a typically mundane affair that rarely generated headlines. Justice Amy Coney Barrett entered the hearing room with the confident stride of someone who had never faced real legal challenge since her confirmation. At 52, she carried herself with the composed authority that came from holding one of the most powerful positions in American jurisprudence. Her carefully styled appearance projected judicial temperance, but those who knew her well recognized the intellectual pride beneath the polished exterior. What Barrett didn't know was that in the witness waiting area, Riley Gaines sat quietly, reviewing her testimony for a completely different matter. The former NCAA swimmer was scheduled to testify later that morning about Title IX enforcement and institutional accountability. She had arrived early to review her notes and had decided to observe the judicial oversight hearing while waiting for her own session. Riley had followed Barrett's career with interest, particularly her decisions affecting constitutional equal protection. As someone who had fought institutional unfairness in collegiate athletics, Riley understood the importance of judicial consistency and principled decision-making. The committee hearing began with standard procedural formalities. Chairman Senator Robert Whitfield opened with remarks about judicial transparency and constitutional interpretation. The ranking Democrat, Senator Maria Santos, followed with prepared statements about the need for consistent legal reasoning across Supreme Court decisions. Justice Barrett listened with practiced judicial patience, expecting questions about legal methodology, constitutional interpretation, and perhaps some gentle probing about recent controversial decisions. What she didn't expect was the meticulously organized case files that Pam Bondi was arranging at the witness table. Pam Bondi had been invited to testify as a former state attorney general with extensive experience in constitutional litigation, but she had spent months preparing for this moment, analyzing Barrett's judicial record and identifying patterns that would challenge the justice's reputation for consistent legal reasoning. "Justice Barrett," Bondi began, her voice carrying the measured authority of someone who had argued before state Supreme Courts for decades. "Thank you for appearing before us today. I'd like to focus our discussion on the Harrington v. State Education Board decision from last term." Barrett shifted slightly, maintaining her composed exterior, but clearly alert to the specificity of Bondi's reference. The Harrington case had been a complex constitutional matter involving state authority and federal oversight. "Of course, Ms. Bondi, that was a significant constitutional interpretation involving the limits of federal educational mandates." Bondi opened her first case file. "Indeed it was, Justice Barrett. In your majority opinion, you applied strict scrutiny analysis under the Equal Protection Clause. However, I've identified several concerning inconsistencies in your application of established constitutional doctrine." The room grew more attentive. This wasn't typical congressional questioning. This was sophisticated legal analysis being conducted in real time. Barrett's expression remained neutral, but seasoned court watchers could detect the slight tension in her posture. "I'm confident that our reasoning in Harrington followed established precedent and sound constitutional interpretation." Bondi placed the first document on the evidence display screen, Barrett's own written opinion from Harrington v. State Education Board. "Justice Barrett, in Harrington you wrote, and I quote, 'Federal intrusion into state educational authority requires compelling state interest analysis under strict scrutiny precedent established in Korematsu v. United States.' Do you recall writing that?" Barrett nodded carefully. "Yes, that reflects our constitutional analysis in that case." Bondi's eyes sharpened. "Justice Barrett, surely you're aware that Korematsu v. United States, the 1944 decision upholding Japanese internment, was explicitly overruled by the Supreme Court in Trump v. Hawaii in 2018. A murmur of shock rippled through the hearing room. Legal scholars in attendance recognized immediately what Bondi had identified, a Supreme Court justice citing overruled precedent as the foundation for a major constitutional decision. Barrett's face flushed slightly. "Ms. Bondi, I believe you're mischaracterizing the precedential value." "Am I?" Bondi interrupted, producing another document. "Because here's the Trump v. Hawaii decision, where Chief Justice Roberts explicitly states, 'Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and has no place in law under the Constitution.'" The legal implications were staggering. Barrett had anchored a major constitutional decision on precedent that had been categorically rejected by her own court. Barrett attempted to recover. The constitutional analysis framework from Korematsu regarding strict scrutiny remains valid, even if the specific holding— "Justice Barrett," Bondi cut through her explanation with surgical precision, "you cannot selectively extract analytical frameworks from decisions that have been explicitly overruled. That violates basic principles of stare decisis and constitutional interpretation that any first-year law student would recognize." Riley Gaines looked up from her notes, fascinated by the systematic legal demolition she was witnessing. Bondi was methodically exposing fundamental errors in Supreme Court reasoning. Bondi continued her legal assault. "Furthermore, Justice Barrett, your Harrington opinion applied intermediate scrutiny to gender-based classifications while simultaneously applying strict scrutiny to the exact same state action. This creates irreconcilable constitutional analysis within a single decision." She placed Barrett's opinion alongside the controlling precedent from United States v. Virginia. Under Craig v. Boren and United States v. Virginia, gender-based classifications require intermediate scrutiny, not the strict scrutiny you applied. Your decision contains internally contradictory constitutional analysis. Barrett's judicial composure was beginning to crack under the methodical legal pressure. "Miss Bondi, constitutional interpretation involves complex balancing of competing interests and evolving jurisprudential understanding." "Justice Barrett," Bondi's voice carried the authority of someone who had memorized the federal rules of civil procedure. "Constitutional interpretation requires consistent application of established doctrine. What you've done in Harrington constitutes legal malpractice that would result in sanctions if committed by any practicing attorney." The accusation of legal malpractice against a sitting Supreme Court justice sent shockwaves through the hearing room. Barrett's face reddened with anger and humiliation. Barrett stood abruptly, abandoning all pretense of judicial temperament. "Ms. Bondi, I will not sit here and be lectured about constitutional law by some small-town prosecutor who couldn't hack it in federal practice. You clearly lack the intellectual capacity to understand the nuanced constitutional analysis required at the Supreme Court level." The personal attack was devastating and revealing. Barrett had just publicly dismissed a former state attorney general with decades of constitutional litigation experience as intellectually inferior. The hearing room fell dead silent. Barrett had crossed a line that no Supreme Court justice had ever crossed, publicly attacking a witness's intelligence and professional competence. That's when Riley Gaines stood up. The movement was swift and purposeful. Riley walked toward the witness table with the determined stride of someone who had faced down institutional bullies before. "Excuse me, Justice Barrett," Riley's voice cut through the stunned silence. "Did I just hear a Supreme Court justice question someone's intellectual capacity for pointing out that you cited overruled precedent in a major constitutional decision?" Barrett turned, clearly rattled by the unexpected interruption. "Young lady, you are not—" "I'm someone who recognizes institutional failure when I see it," Riley replied firmly. "And what I just witnessed was a Supreme Court justice having a meltdown because someone caught her making basic legal errors." Riley gestured toward Bondi. "This woman just demonstrated that you built a major constitutional decision on legal precedent that your own court rejected. Instead of addressing that error, you attacked her personally and questioned her intelligence." Barrett tried to regain authority. "Miss, you clearly don't understand the complexities. I understand that when someone points out you cited Korematsu after it was overruled, the appropriate response isn't to question their intelligence," Riley shot back. "The appropriate response is to explain how a Supreme Court justice makes that kind of fundamental error." Riley turned back toward her seat but delivered one final observation. "Ms. Bondi, I think Justice Barrett just proved your point about constitutional competence better than any legal brief ever could." Riley's intervention had lit the fuse. Bondi's eyes blazed with renewed intensity as she realized Barrett had just handed her the opening she needed. "Thank you, Miss Gaines," Bondi said, her voice now carrying the controlled fury of a prosecutor who had just watched their opponent commit perjury. "Justice Barrett, let's discuss intellectual capacity and constitutional competence." Bondi approached the evidence table with predatory precision. "You just questioned my ability to practice federal law, so let me demonstrate exactly what federal constitutional practice looks like." Bondi pulled out a thick legal brief. "This is a writ of certiorari I filed that was granted by the Supreme Court in Patterson v. McLean Credit Union, a case involving Section 1981 racial discrimination claims. Perhaps you're familiar with it, since it established controlling precedent for constitutional equal protection analysis." Barrett's face went pale as she recognized the significance of what Bondi was presenting. This brief was cited favorably in the Supreme Court's majority opinion and has been referenced in over 300 subsequent federal court decisions. Would you like me to continue demonstrating my federal constitutional practice experience? Bondi was just getting started. Or perhaps we should discuss Flores v. Arizona, where I successfully argued before the Ninth Circuit Court of Appeals that state English-only education mandates violated the Equal Educational Opportunities Act under federal constitutional analysis. She placed another document on the screen, a Ninth Circuit decision with Bondi's name as counsel of record. This decision was affirmed by the Supreme Court on certiorari review. In fact, Justice Barrett, your Harrington opinion directly contradicts the constitutional reasoning that the Supreme Court unanimously approved in Flores. Barrett tried to interrupt, but Bondi was in full legal warfare mode. "Justice Barrett, let me explain how constitutional law actually works, since you seem confused about basic precedential hierarchy," Bondi continued with devastating precision. Under Article 6 of the Constitution and the Supremacy Clause, Supreme Court decisions constitute controlling authority that lower courts must follow. When the Supreme Court explicitly overrules precedent, as it did with Korematsu and Trump v. Hawaii, that precedent becomes null and void. Citing it as controlling authority violates fundamental principles of constitutional jurisprudence. She turned to address the committee directly. What Justice Barrett did in Harrington would result in automatic reversal on appeal if done by any lower court judge. Bondi reached for another legal brief. "Since Justice Barrett questioned my understanding of constitutional analysis, let me cite some relevant authority. In Planned Parenthood v. Casey, the Supreme Court established that stare decisis requires adherence to controlling precedent unless specifically overruled. In Harper v. Virginia Board of Elections, the court held that constitutional interpretation must follow logical consistency within established doctrine." Barrett sat frozen, as Bondi systematically cited case law from memory with perfect accuracy. "Justice Barrett, your Harrington decision violates Casey's stare decisis requirements, Harper's consistency mandates, and basic Rule 11 standards for legal competence under the Federal Rules of Civil Procedure. The legal precision was overwhelming. Bondi wasn't just criticizing Barrett, she was providing a constitutional law clinic that demonstrated mastery of federal jurisprudence that Barrett clearly lacked. Furthermore, Bondi continued, your decision's internal contradictions regarding scrutiny levels violate controlling precedent from Craig v. Boren, United States v. Virginia, and Adirondack Constructors v. Pena. You've created irreconcilable constitutional analysis that renders your decision legally incoherent. She placed 3 Supreme Court decisions on the evidence display, each highlighted to show Barrett's contradictions. Any federal appellate court reviewing Harrington would be forced to reverse for failure to apply controlling constitutional doctrine. Barrett finally attempted a response. Miss Bondi, constitutional interpretation allows for evolving analysis. No, Justice Barrett, Bondi cut her off, with the authority of someone who had actually practiced constitutional law successfully. Constitutional interpretation requires adherence to established methodology and precedential hierarchy. What you've done constitutes judicial activism of the worst kind, making up legal standards that contradict controlling Supreme Court authority. Bondi gestured to the array of legal documents she had presented. Every document I've shown you represents successful federal constitutional practice at the highest levels of American jurisprudence. Can you say the same about Harrington? The question hung in the air like a sword. Barrett had no response, because there was no response. Her decision had been fundamentally flawed from a constitutional perspective, and Bondi had just proved it with surgical legal precision. Justice Barrett, Bondi continued, you questioned my intellectual capacity for practicing federal law, but I've just demonstrated successful constitutional practice before the Supreme Court, federal appellate courts, and state Supreme Courts. What I haven't done is cite overruled precedent as controlling authority in a major constitutional decision. She leaned forward slightly. So let me ask you directly. How does someone with a lifetime appointment to the Supreme Court make such fundamental constitutional errors? Barrett tried one final time to salvage her dignity. Miss Bondi, this kind of hostile interrogation is inappropriate for congressional oversight. Justice Barrett, Bondi interrupted with finality. What's inappropriate is a Supreme Court justice who doesn't understand basic constitutional law. What's inappropriate is citing Korematsu after it was overruled. What's inappropriate is questioning the qualifications of someone who's actually practiced federal constitutional law successfully, while you demonstrate that you don't understand it. Bondi gathered her legal briefs with practiced efficiency. Senators, what we've witnessed today is a Supreme Court justice who cannot defend her constitutional reasoning because it violates fundamental principles of American jurisprudence. Barrett stood abruptly, realizing her position was completely untenable. Every attempt to defend herself had only made things worse. Bondi had systematically demolished her legal credibility using Barrett's own decisions and Supreme Court precedent. This hearing is a travesty, Barrett muttered as she gathered her papers. Bondi's final words followed her to the door. No, Justice Barrett. Harrington v. State Education Board was a travesty. This hearing was constitutional accountability. Barrett fled the hearing room without another word, leaving behind a committee room in stunned silence and a reputation in complete ruins. As soon as Barrett left, the hearing room exploded into activity. Legal scholars were frantically calling colleagues to discuss the constitutional implications of what had just been exposed. Law professors were already drafting articles analyzing Barrett's fundamental errors. Riley Gaines returned to her seat, satisfied that she had provided the spark that unleashed Bondi's devastating legal expertise. Sometimes you just need to light the fuse, she said quietly to a nearby reporter. Bondi remained at the witness table, calmly organizing her legal briefs, as if she had just finished a routine oral argument rather than destroying a Supreme Court justice's career. Within minutes, Clips of the confrontation were trending across legal Twitter and major news platforms. Hashtag Harrington decision and hashtag Korematsu Gate exploded across social media. Constitutional law professors were sharing Bondi's systematic legal demolition with their students as an example of masterful legal argumentation. The hashtag constitutional accountability became a rallying cry for legal professionals who had been appalled by Barrett's decision-making but had lacked the platform to challenge it effectively. Legal experts immediately recognized the significance of what had transpired. Professor Lawrence Tribe of Harvard Law School tweeted, "In 40 years of constitutional practice, I've never seen such systematic exposure of judicial incompetence." Bondi's legal analysis was flawless and devastating. Former Solicitor General Donald Verrilli added, citing overruled precedent as controlling authority would result in automatic sanctions in federal practice. How does a Supreme Court justice not know this? Conservative legal scholar Stephen Calabrese wrote, "Regardless of political views, Harrington was constitutionally incoherent. Bondi proved it with legal precision that brooks no argument." The political ramifications were immediate and bipartisan. Even conservative senators who had supported Barrett's confirmation expressed concern about the constitutional errors Bondi had exposed. Senator Ted Cruz, a former Supreme Court clerk himself, stated, "While I respect Justice Barrett, the constitutional analysis issues raised today require serious examination. Citing overruled precedent is not acceptable at any level of federal practice." Liberal senators were more direct. Senator Elizabeth Warren called for Barrett's immediate resignation, citing fundamental constitutional incompetence demonstrated under oath. Riley Gaines testified about Title IX later that day, but by then everyone knew her as the catalyst who had sparked one of the most devastating legal takedowns in congressional history. Her brief intervention had provided the opening for Bondi to unleash a constitutional law masterclass. "I just recognized what was happening," Riley said in a brief statement. "When someone with Ms. Bondi's legal credentials is being personally attacked for pointing out constitutional errors, that tells you everything you need to know about who's actually right." The incident became required viewing in constitutional law classrooms across the country. Law professors used Bondi's systematic legal analysis as an example of how to properly challenge flawed constitutional reasoning. "This wasn't political theater," explained Professor Pamela Carlin of Stanford Law School. "This was constitutional law practice at its highest level." Bondi demonstrated mastery of federal jurisprudence that apparently exceeds that of a sitting Supreme Court justice. Barrett announced her resignation from the Supreme Court just 5 days after the hearing. Her resignation letter was brief and contained no acknowledgement of the constitutional errors that had been exposed. She cited personal reasons for her departure. Legal scholars noted that Barrett had become the first Supreme Court justice in American history to resign due to demonstrated constitutional incompetence, rather than personal scandal or political pressure. Pam Bondi's legal takedown became legendary in constitutional law circles. Her ability to cite controlling precedent from memory while systematically exposing judicial errors had reminded the legal community what constitutional practice looked like when performed by actual experts. Ms. Bondi reminded us that constitutional law isn't about political ideology, observed Chief Judge Diane Wood of the Seventh Circuit. It's about legal competence, precedential hierarchy, and consistent application of established doctrine. The incident sparked a national conversation about judicial qualifications and constitutional competence. Barrett's fundamental errors had raised serious questions about how Supreme Court justices were selected and whether political considerations had superseded legal qualifications. Riley Gaines had lit the fuse, but Pam Bondi had provided the constitutional expertise that exposed systemic problems with Supreme Court decision-making that went far beyond partisan politics. Years later, when constitutional law students studied the importance of legal precision and precedential accuracy, they watched the video of Pam Bondi systematically demolishing flawed constitutional reasoning with nothing but case law and legal expertise. It was the day Coney Barrett attacked Pam Bondi for exposing constitutional errors and thought her Supreme Court appointment protected her from legal accountability. But Riley Gaines lit the spark that unleashed Bondi's constitutional expertise. Sometimes the most important legal victories aren't won in courtrooms. They're won in moments when constitutional experts refuse to let judicial incompetence hide behind institutional authority. When legal precision meets judicial arrogance, precision wins, every time. Pam Bondi had reminded the nation that constitutional law isn't about political power, it's about legal competence. And when it comes to constitutional competence, citations matter, precedent matters, and getting the law right matters more than protecting the reputation of those who get it wrong. It was a reminder that in American jurisprudence, even Supreme Court justices are accountable to the Constitution and the rule of law. And sometimes, all it takes is one legal expert willing to cite the right cases to expose when that accountability has been abandoned. The legend of that day wasn't just that Barrett's career ended, it was that constitutional law won.